Most people have no idea that what just happened in the Supreme Court could completely change how you plan your move to the United States. And I'm not talking about something small. I'm talking about a decision that could affect your job offer, your visa sponsorship, your cost of living, and even whether your future employer in the United States can actually afford to hire you. If you've been watching the news and feeling confused, or maybe a little scared, you're not alone. Today, we're going to break all of this down in plain English so you actually understand what's happening, what it means for you personally, and what steps you might want to consider right now before things shift even further. Welcome back to Us Visa Explained, the channel where we take the most complicated parts of American immigration and make them simple, honest, and actually useful for real people going through this process. If you're new here, make sure you hit that subscribe button right now because we cover everything from visa applications to green cards to citizenship, and we do it without the confusing legal jargon that leaves most people more lost than when they started. And if you've been here for a while, you already know that when something big happens in the immigration world, this is the place you come to get the full picture. So let's get into it. Let's talk about what the Supreme Court actually ruled, why tariffs have anything to do with immigration, and most importantly, what this means for you if you're trying to build a life in the United States. To understand why this matters so much, we first have to take a step back and talk about what tariffs actually are, because a lot of people hear the word tariff and immediately switch off. They think it's a business thing, an economics thing, a politics thing, and yes, it is all of those things, but it is also a you thing. It affects your life directly whether you realize it or not. A tariff is basically a tax that the government puts on goods that come into the country from other places. So if a company in another country is selling products to American businesses or American consumers, the US government can say, okay, you want to sell your goods here? You're going to have to pay an extra fee to do that. And that fee gets passed on to whoever is buying those goods, which usually means American businesses, and then eventually American consumers, and then eventually you, if you're living and working in the United States. Now, the question that went all the way to the Supreme Court was not whether tariffs are good or bad. The question was much more specific and much more important from a legal standpoint. The question was this: does the President of the United States have the legal authority to impose sweeping tariffs on his own without getting specific approval from Congress each time? Or does that kind of power need to go through Congress first? This might sound like a technical legal debate, but the answer has enormous consequences, and the Supreme Court has now weighed in. And depending on how you look at it, the ruling either gives the executive branch a massive amount of economic power, or it sets a limit on how far that power can stretch. Let's break down what the court actually said, what it means going forward, and then let's connect it directly to immigration. The court's decision essentially came down to the interpretation of laws that were passed decades ago, laws that gave the president broad authority to impose tariffs in situations involving national security or economic emergencies. For years, presidents have used these laws as justification for imposing tariffs quickly and without waiting for a long congressional process. The argument from the executive branch has always been that in a fast-moving global economy, the president needs to be able to act quickly. Waiting months for Congress to debate and vote on a tariff could mean missing a critical window. The opposing argument made by businesses, trade groups, and some members of Congress was that this kind of sweeping economic authority was never meant to be handed entirely to one person. That Congress, which is the branch of government that is supposed to control the power of taxation and trade under the Constitution, was being bypassed, and that the courts needed to step in and clarify the boundaries. What the Supreme Court did was essentially say that while the president does have real authority here, that authority is not unlimited. The court drew lines. It said that certain uses of emergency tariff powers need to meet specific standards. It said that presidential power in this area, while broad, can be reviewed and challenged. And it sent a signal to both the executive branch and to Congress that the legal framework around tariffs needs to be clearer, more structured, and more accountable. Now, some legal experts are saying this is a huge win for checks and balances. Others are saying the ruling still leaves the president with enormous tariff power and that not much will change, practically speaking. And honestly, both of those takes have some truth to them. But here is what we know for certain. Tariffs that are already in place are likely to remain in place for a significant period of time. New tariffs may face more legal challenges going forward, and the economic environment that these tariffs have created, particularly the higher prices, the strained supply chains, and the pressures on businesses, is the environment that immigrants and visa holders are navigating right now. So let's talk about what that actually looks like on the ground. One of the biggest ways this affects immigrants and people trying to come to the United States is through the job market and employer sponsorship. A huge percentage of people who come to America on employment-based visas, whether that's an H-1B, an L-1, an O-1, an EB-2, or an EB-3, they are dependent on a U.S. employer being willing and able to sponsor them. That sponsorship is not free for the employer. It involves legal fees, filing fees, compliance costs, and sometimes years of commitment. Employers only do this when they believe the value of that worker is worth all of that investment. When tariffs raise the cost of doing business, companies start looking at every line item in their budget. They look at where they can cut, where they can delay, and where they can simplify. And sometimes, unfortunately, international hiring and sponsorship ends up in the category of things that get put on hold or cut entirely. Not because the company doesn't value international talent, but because the financial pressure from a higher cost environment forces hard decisions. We've already been seeing this in certain industries. Technology companies that rely heavily on imported hardware components have seen their costs go up. Manufacturing companies that source materials from abroad have faced higher prices. Even some healthcare and logistics companies have felt the ripple effects. And when company revenues get squeezed, hiring freezes happen, sponsorships get delayed, and some workers who are expecting job offers find themselves waiting much longer than anticipated. If you are in the H-1B process right now, or if you're waiting on an employer to file a petition for you, this is something you need to be aware of. It doesn't mean your opportunity is gone, but it does mean you should be having open conversations with your sponsoring employer about their timeline, their financial stability, and their commitment to moving forward with your case. You don't want to find out 6 months from now that the company quietly paused its sponsorship program without telling you. Now let's talk about the cost of living piece, because this is something that people planning to move to the United States need to factor into their financial planning in a much more serious way than they might have a few years ago. Tariffs raise the price of imported goods, and the United States imports an enormous amount of goods: electronics, clothing, furniture, food products, vehicles, building materials. The list goes on and on. When tariffs go up on these categories, retailers don't just absorb that cost, they pass it on to consumers, which means that when you move to the United States, the day-to-day cost of setting up your life, furnishing your apartment, buying a car, purchasing electronics for your home or your work, feeding your family, all of that costs more in a high tariff environment than it did just a few years ago. This is important for financial planning purposes. If you have savings or a budget in mind for your first year in the United States, you may want to revise those numbers upward. Talk to people who have recently moved to the cities or regions you are considering. Get real numbers from real people about what it actually costs to live there right now. Do not rely on cost of living estimates from 2 or 3 years ago, because those numbers may no longer reflect reality. The other thing to be aware of is how tariffs can affect your salary expectations and your visa wage requirements. Some employment-based visas, particularly the H-1B, have prevailing wage requirements. The government requires employers to pay sponsored workers at least the prevailing wage for their role and their location. Those wages are supposed to reflect what workers in that field are actually being paid in that area. But wage data takes time to update. And in a high inflation, high cost environment driven partly by tariffs, the actual cost of living can outpace the official wage benchmarks. So even if you're being paid the prevailing wage on paper, you want to make sure you're negotiating a salary that actually covers your real expenses in your actual location. Let's also talk about how this affects people who are already in the United States on a visa or in the green card process. If you are on an H-1B visa and your employer is facing financial pressure, one of the things you want to monitor closely is whether your employer is at risk of layoffs or significant workforce reductions. We've seen waves of layoffs in the technology sector over the past couple of years, and in a higher cost economic environment, more companies could face pressure. If you are laid off on an H-1B, you have a grace period, typically 60 days, to find a new employer who will sponsor you or to change your status. 60 days sounds like a reasonable amount of time, but in a competitive job market where many employers are being cautious about hiring, it can go very fast. If you are in the middle of the green card process, specifically the employment-based green card process, you want to make sure your employer's situation remains stable. One of the requirements for maintaining your green card petition is that the job offer underlying your petition remains genuine and that the employer still intends to employ you when your green card is approved. If your company goes through significant layoffs, restructuring, or a change in financial circumstances that can create complications for your pending petition, this is absolutely something to discuss with an immigration attorney if you have any concerns. Now let's zoom out and talk about the bigger picture of what this Supreme Court ruling signals for the future of U.S. immigration policy. One of the things that many immigration analysts have been watching carefully is how economic policy and immigration policy interact with each other at the federal level. Historically, these have been somewhat separate conversations. Trade and tariffs were handled in one set of congressional committees and agencies. Immigration was handled in another. But increasingly, we are seeing these two areas become intertwined. The argument made by some policymakers is that the same forces that drive tariff policy, protecting American workers, reducing dependence on foreign goods, strengthening domestic industries, are also relevant to immigration policy, and that immigration levels and the types of workers who are let into the country should be calibrated to serve those economic goals. Whether you agree with that framing or not, the political reality is that it matters, because it means that decisions made in the trade and tariff space can have downstream effects on visa policy, on processing priorities, and on the overall environment for immigrants in the United States. We've already seen some of this play out. There have been discussions about tightening H-1B requirements to ensure that companies are genuinely not able to find qualified American workers before turning to international candidates. There have been proposals to change the wage thresholds for sponsored workers. There have been debates about which job categories should qualify for fast-tracked immigration processing. All of these debates are at least partly influenced by the economic and political environment created by tariff policy and trade disputes. So as someone navigating this system, you want to stay informed not just about immigration news, but about the broader economic and policy environment. Because changes in that environment can translate into changes in your visa category, your processing times, your employer's ability to sponsor you, and your overall path to permanent residency. Let's talk about specific visa categories and how they may be affected going forward. For H-1B holders and applicants, the key things to watch are employer financial health, wage requirements, and any potential regulatory changes to the H-1B program. The H-1B lottery system already makes this path extremely uncertain, and in a tighter economic environment, The number of employers willing to file cap subject petitions may fluctuate. For L1 visa holders who are transferred within multinational companies, the financial health of the parent or affiliate company overseas matters enormously. If the foreign entity is facing economic pressure from tariffs or trade disruptions in their home market that can affect their ability to maintain or expand U.S. operations, which directly impacts L1 transfers. For EB1, EB2, and EB3 green card applicants, the main concerns are around priority dates, employer stability, and the potential for policy changes that affect how these categories are processed or how many visas are allocated. The backlog in employment-based green cards, particularly for applicants from India and China, is already measured in years and in some cases decades. Any policy shift that changes how visas are distributed within these categories can have life-altering implications. For F1 students who are planning to use optional practical training or who are hoping to transition from a student visa to an employment-based visa, the job market environment matters more than almost anything else. Your ability to find a sponsoring employer after graduation is directly tied to whether companies in your field are hiring, expanding, and willing to take on the commitment of sponsorship. In a cautious economic environment, that can be harder to find. For family-based immigrants, the economic environment has a somewhat different but still significant impact. The financial requirements for sponsors of family-based immigrants, the affidavit of support requirements, are tied to federal poverty guidelines. And in a high-cost, high-inflation environment, meeting those requirements while also managing the rising cost of living becomes more challenging for some petitioners. Now let's talk about what you can actually do, because I never want to leave you with just a picture of the challenges. I want to give you real, actionable things to think about and to act on. The first thing is to educate yourself on your specific visa category and what the current requirements are. Immigration rules change, processing times change, fee structures change. Don't rely on information you read 2 years ago. Go to the USCIS website, talk to a qualified immigration attorney. Make sure you understand exactly where you stand and what the current requirements are for your path. The second thing is to build relationships with your employer's HR team and whoever manages your immigration case internally. Make sure you are visible, valued, and that the people making decisions about sponsorship know your name and your contributions. In an environment where companies are being cautious, the people who get sponsored are the ones who are seen as essential. The third thing is to have a financial cushion and a contingency plan. Whether you are already in the United States or planning to come, having savings that can carry you through a period of transition, whether that's a job change, a visa gap, or an unexpected delay, is more important than ever. Know what your options are if your primary path hits a roadblock. The fourth thing is to stay connected to reliable sources of information. Subscribe to channels like this one. Follow reputable immigration attorneys and policy analysts. Read the official USCIS and State Department updates. When something changes, you want to know about it quickly so you can respond, not find out 6 months later when it's already affected your case. The fifth thing is to document everything. Every communication with your employer about your immigration case. Every filing, every receipt notice, every request for evidence, every approval. Keep a complete, organized file of your entire immigration history. This is your life and your legal status. Treat it with that level of seriousness. And the sixth thing is to advocate for yourself. If you have questions, ask them. If something doesn't seem right, raise it. If you are unsure about your status or your next steps, consult a professional. The people who navigate this system most successfully are not the ones who wait and hope things work out. They are the ones who stay informed, stay engaged, and take action. The Supreme Court's tariff ruling is a reminder that the legal and economic landscape in the United States is always evolving. And for immigrants and aspiring immigrants, that evolution creates both challenges and opportunities. The challenges are real, and we should not minimize them. But so are the opportunities. The United States continues to be one of the most powerful economies in the world. It continues to attract talent from every corner of the globe. And the people who succeed here are the ones who understand the system, adapt to it, and keep moving forward. We will continue to cover all of the developments that affect your immigration journey right here on this channel. If there are specific topics you want us to cover, drop them in the comments below. If you found this video helpful, please share it with someone else who is going through this process, because one of the most powerful things you can do is help someone else navigate this system with a little more clarity and confidence than they had before. Thank you so much for being here, for watching all the way to the end, and for trusting us, Visa Explained, to help you make sense of what is honestly one of the most complex and important decisions of your life. We take that trust seriously, and we will keep showing up for you with honest, thorough, and genuinely useful information. We'll see you in the next video.